Ladies and gentlemen, the President of the Senate of the Republic of the Philippines, Dr. Franklin M. Drilon.
Dr. Patricia Diliman, the Chair of the UP Board of Regents, President Alfredo E. Pascual, President of the University of the Philippines, officials of the UP system, members of the Committee on Honorary Degree, Dean Danilo Concepcion, our Dean of the UP College of Law, Associate Dean Concepcion Hagdileza, the faculty of the UP College of Law, Justice Amor Herrera, Solicitor General Francis Hagdileza, the other officials of government, my co-workers in government present here this afternoon, members of the faculty, friends, graduates of the class of 2014, a pleasant good afternoon to all. It is with great sense of humility that I accept this honor that you have bestowed on me today. To be honored in this grand manner, conferment of Doctor of Laws honoris causa by my beloved alma mater was beyond my imagination when I graduated from the UP College of Law 45 years ago. With immense pride and joy, I share this honor with my family and the people who have been with me in my journey. I dedicate this honor to my late father, Cesar Drilon Sr., who would have been 94 today. Maraming salamat po sa inyong lahat. Ladies and gentlemen of the class of 2014, Mary Smith, in an article in the Chicago Tribune entitled "Advice Like Youth, Probably Just Wasted on the Young," which, as you know, was made into a song, "Everybody's Free to Wear Sunscreen" by Baz Luhrmann, wrote, quote, "Enjoy the power and beauty of your youth. Don't worry about the future. The real troubles in your life are apt to be things that never crossed your worried mind. Don't waste your time on jealousy. Sometimes you're ahead, sometimes you're behind. The race is long, and in the end, it's only with yourself. Remember compliments you receive. Forget the insults. Whatever you do, don't congratulate yourself too much or berate yourself either. Your choices are half chance, so are everybody else's. And wear sunscreen." I quote Mary Smith because she tells us of some truths that are quite apt on this memorable event in your life. The reference to power and the beauty of youth is a reminder that while we dream of the future ahead of us, keeping ourselves grounded in the present is just as important. Don't worry about the future, she said, for when we face an uncertain future, we tend to worry or fear, but that will only take away today's strengths and not tomorrow's troubles. Since lawyers are by nature competitive, I find appealing the author's advice. Sometimes you're ahead, sometimes you're behind. The race is long, and in the end, it's only with yourself. End of quote. The best embodiment of this is our fascination with the bar examinations. At this point, let me pause and congratulate the UP class of 2013 for its dominating performance in the recent bar examination. It is reminiscent of my class performance in 1969. Perhaps your class, the class of 2014, can exceed that. The enthusiasm is very muted, I wonder. But let us not be bogged down by the spirit of competition if it leads to division and acrimony. Mary Smith teaches us to remain humble and optimistic. Don't congratulate yourself too much, he said, or berate yourself either. We must always remind ourselves that we are not in control of everything. There is always something left to chance, to luck, or our belief in a higher being. My dear graduates, ladies and gentlemen, lawyers are often called creatures of conflict. We thrive when there is a dispute. Our system of litigation is one that is adversarial by design. This system remains to be the bedrock of a democratic framework where a third-party arbiter can resolve disputes between two combatants objectively. In reality, the results and even the process of litigation are imperfect. Cases in our courts take too long to resolve. We must address this, especially as it concerns the Sandigan Bayan. Filing cases against erring public officials is hardly a deterrent because the anti-graft court is burdened with thousands of cases that takes an average of anywhere from 5 to 7 years to resolve. A priority in the Senate's agenda is Senate Bill number 2138, a measure that I principally authored, which seeks to fortify the structural capability of the Sandigan Bayan to effectively resolve the graft cases that have multiplied over the years. This bill introduces certain innovations, such as the justice designate concept, transfer of the so-called minor cases to the regional trial courts, and modification of the voting requirement in rendering decisions. There are mechanisms already in place which are meant to reduce the acrimony in court litigation and consequently accelerate the process. There is a trend to depart from the traditional modes of resolving disputes where the parties are combatants. Our rules of court already provide for the modes of discovery. The rules on pre-trial were strengthened. The Supreme Court mandated the use of judicial affidavits and highlighted the value of court-annexed mediation and judicial dispute resolution where litigants are given the opportunity to avoid court litigation by being exposed to dispute settlement. Congress, on the other hand, enacted the Alternative Dispute Resolution Act, which recognized the importance of the ADR in the achievement of speedy and impartial justice. All these rules are laudable, and we should continue to march towards their full utilization. But over and above all this, I am proposing a paradigm shift. Lawyers should be problem solvers rather than gladiators. They should be more result-oriented than procedure-based. Lawyering has always been a subject of interest to people outside the legal community. The practice of law and the rules that govern it often mirror the rules that keep society in order. Because lawyering mirrors the functioning of society in general, the legal community is a good template for a control group or a petri dish for effecting changes in society. Today, our country is moving towards achieving true participatory democracy. It is characterized by a government that is focused on consensus building, one that is interested in arriving at solutions through consultations, a government that attempts to find answers that are beneficial to as many people as possible, instead of being concerned with factionalism where one group must always prevail over another. If this is the goal, and if our profession mirrors the aspirations of our society, it is about time that we move away from being combatants and embrace our roles as result-based problem solvers. However, much like the existing government structures and institutions, the practice of law in this country is characterized by delays. This in turn is brought about by a mindset that relies on rules and routine. Lawyers and judges appear to be resigned to the likelihood that cases will drag on for years. Often, rules are used to even further delay cases. In effect, the rules that govern court litigation become the very tools that stall the judicial system. There is therefore a need to change the perspective of lawyers and judges as to the handling of legal disputes. While resolving disputes in accordance with long-established and time-honored procedure is essential, the resolution of disputes in this manner may not always be a complete solution to all legal problems. When lawyers face each other as gladiators, the result is always a winner-take-all situation. However, as officers of the court, the duty of lawyers is not merely to arrive at a determination of who wins and who loses. Rather, the duty of the lawyer is to see to it that justice is done. Thus, there is a need to recalibrate the process by which solutions to legal disputes are attained. Judges and lawyers should be more interested in attaining just results rather than an overly strict compliance with the rules. Legal disputes should be settled not on the basis of who is more capable of using legal procedures to his advantage, but rather on the basis of who has a clear right in the law. The Supreme Court, as early as 1911, ruled in Manila Railroad versus Attorney General that the purpose of procedure is not to thwart justice. It rather exists to facilitate its application to the rival claims of the contending parties. It was created not to hinder and delay, but to promote the administration of justice. It is a means to an end.